All right, welcome to the second of the 2011-2012 English lecture series. Today our speaker is Dr. Syugo Hotta. He is professor of law at Meiji University. He flew in today from Osaka for this lecture today for us. So I will turn over the floor to him. He's a wonderful speaker. I've heard him speak before, and I'm sure it's going to be a wonderful presentation today.
Excellent. I'd like to thank, first of all, Sean and people here for inviting me as a speaker of this wonderful lecture series. And I'm very honored and flattered to be here with you. I've heard most speakers of this lecture series talk about some business-related topics, but my topic is not really business-related. But my topic is something that has something to do with your life in the future. So I hope you enjoy my talk. Anyway, let's get started. Right, yeah. I always, play around with my Microsoft PowerPoint slides like this. Anyway, this is what I usually teach. Alright, so as you know, Japan has introduced a new trial system called the lay judge system. In Japanese, we call Saiban Seido, right? This was started in on May 21st in 2009, as you know. I'm going to talk a little bit about the Saiban Seido first, and then go on to the topic about language and law, right? Okay. Anyway, under this new system, lay people called lay judges. Okay, we call Saiban lay judges in English, and professional judges, shokugyo saibankan, put heads together. Okay, gather and think together, and find or judge or decide whether the defendant, hikokuni, is guilty or not guilty, and what an appropriate sentence is. So they decide guilt and sentencing. Okay, two things. Okay, guilt and sentencing. So the Japanese legislative system is often compared with the foreign systems like jury system in American or British system. The difference between the jury system is, first, under the jury system, only lay people participate in the discussion. So no professional judges are involved in the discussion process. Okay? And also, under the jury system, there's no sentence discretion. Oops, too fast. What were we talking about? Okay, this one. So they don't really decide what an appropriate penalty is, right? So they only decide whether the defendant is guilty or not guilty. So that's the biggest difference. Right. Okay, now let me ask you a question. So how many lay judges sit in the panel? How many lay judges participate in the court? Okay, 1, 3. Okay, A, 3. B, 5. C, 6. Write down your answer anywhere. Do you have a handout or something? All right. The correct answer is 6. Okay. Now let me ask you this question. How many professional judges sit in the panel? How many professional judges? Good. A, 1. B, 3. 3, 5. Well, the answer is really obvious. The correct answer is 3, right? So in most cases, 3 professional judges and 6 lay judges sit together in the panel. But if the defendant confesses his guilt, if the defendant admits that he committed the crime, only 1 judge and 4 lay judges participate in the discussion. Okay, so there are 2 patterns. Anyway, how are they selected? How are the lay judges selected? The candidates for the lay judges are randomly selected out of the electoral register. Sorry, electoral register. I'm a bit nervous today. Sorry. Thinking in minute. Okay. And candidates are selected for each case. Okay, that's another difference from the European system. In the European jury system, we call the lay judge system. Okay. In many European countries, the same kind of system is has been introduced, especially in France and Germany. They have the lay judge system, so judges and lay judges put heads together and discuss the case. But they are appointed for a year or 2 years or 3 years, so they are appointed for a long period of time. But in Japan, candidates are selected just for each case. Okay, that's the difference. And anyway, they are summoned to the court on a day of trial. Trial is saiban. At the court, after being interviewed by judges, prosecutors are kensatsuka. Sorry, I forgot to put the boss there. Prosecutors are kensatsuka. Okay, and defense lawyers, they are bengoshi or bengonin. Okay. Anyway, the lay participants are interviewed by judges, prosecutors, and defense lawyers, and they will be the final lay judges. I mean, the lay judges who actually go to the court in the case are selected by lottery. They usually use a ball, and the ball has a number, and if a number is called, the selected lay judge goes to the courtroom actually. Right. Anyway, the cases lay judges deal with. The first one is the cases whose heaviest punishment is either death penalty or life imprisonment. Well, life imprisonment is not a real accurate term, but we customarily use it. Life imprisonment is actually shushinke, so you can never get out of the jail usually. But in Japan, that punishment doesn't really exist. But for some reason, people use this term to express mukichoeki in English. So anyway, the second type of cases is the cases resulting in the victim's death caused by the perpetrator. Perpetrator is a criminal. Okay, criminal's intentional criminal act, which law requires multiple judges to discuss. Usually, only one judge decides a case, but there are some cases that law requires more than one judge to discuss. Okay, so those cases are discussed by lay judges, and for example, such felonies as murder, robbery causing death or injury, goto chisho or goto chishi, and arson of arson of inhabited buildings. If there's nobody living there, and somebody put a fire on the building, he's not being sent to the. He's not treated as a saiban criminal. I don't know if that's the right word. Anyway, so the cases are sort of limited. But for some reason, they only discuss felonies and serious cases. There are a lot of discussions about it. So why do lay people go to the court? Well, so what are lay judges called for? Why do we need lay judges? One reason is to promote the public involvement in the judicial process. So we call it like 国民的基盤の確立, so promotion of democracy. So if we have more people in the judicial process, they believe that the more democracy can be achieved. So, and the second reason is to reflect citizen sense on legal decisions. So it's called 市民感覚の反映. And I find this one is more important. I find this one more important. Anyway, these are then the two major reasons to introduce. These are two major reasons that Japan has introduced the lay judge system. Okay, anyway, all advanced countries but Japan are said to have some sort of lay participation system. As I said, French, Germany, and the US, England, they all have some sort of lay participation system in different, in one form or another, Sorry, for some reason my mouse doesn't really run smoothly. Okay, and can we really judge things like professional judges? You may worry about this, right? Because we are amateurs. We don't know about law at all. Can we really judge like professional judges? Well, according to research, okay, this is a real academic research, professional judges and lay people show a little difference, or almost no difference, as to fact finding. So when we decide whether the defendant is guilty or not guilty, we can make the same kind of judgment as professional judges. Okay, that's why lay people are really trustworthy, and we should have them in the court. Anyway, we don't know law, so we are very worried. So we know nothing about law, but can we really serve a mixed jury? By the way, mixed jury is another term to express the裁判員制度. Anyway, so all in the裁判員 trial or in a legal trial, all you need is your common sense, and viewpoints, your own viewpoints. These are the most important things. So professional judges are there to help you. So if you have trouble understanding some expressions used by lawyers, they're going to help you, right? So you don't have to worry about it all. And also, we don't know law. So sometimes questions of law will cause you some problem. But law requires judges to decide questions about law. So we don't have to worry about the difficulty in deciding about the questions of law. And if you have trouble understanding anything, anyway, judges will explain to you, in easier terms. Well, this is really annoying. Sorry. Language problems you might think of as I'm a linguist, as a professional. How could I say? I'm a specialist of language, so. I'm more interested in language problems in the courtroom. Okay? So the first language problem you might think of is, do lawyers use legalese, legal terms, technical terms? Yeah, you're very scared, right? But you don't have to worry about it. Judges, prosecutors, and defense lawyers are trying hard to use as easy expressions as possible. They are even publishing a dictionary so that lay people can understand what they talk about. So technical terms are not a big problem actually. So I'm going to talk about some other problems that you have to think about in participating in a new era where裁判 trials are held. Okay, so this is the real topic I'm going to talk about today. Okay, trials and power of language. By the way, this is my book. Okay, I want you to watch this movie. Okay.